Thank you, Mr. Speaker. The government has proclaimed a public order emergency under the Emergencies Act. The question before us today in this House is whether the proclamation is consistent with the law. For a public order emergency to be proclaimed to deal with the blockades here in Ottawa and across the country, three criteria must be satisfied. First, there must be an urgent, critical, and temporary situation where there is serious violence or the threat of serious violence against people or property for the purpose of achieving an ideological, religious, or political objective. Arguably, the government has met this first criterion. The RCMP raid in Coutts, Alberta resulted in the seizure of high-powered guns with scopes, handguns, ammunition, high-capacity magazines, and body armor decorated with patches associated with white supremacist and other extremist groups. 13 people have been charged in connection with the seizure, including four with plotting to murder police officers. The RCMP say these individuals were organized, highly armed, and dangerous. In addition, some of the organizers of the blockade here in Ottawa used language that suggested they were ideologically motivated and willing to use force to achieve their ends. The second criterion that must be met is that either the situation endangers the lives, health, or safety of Canadians and is of such proportions or nature as to exceed the capacity or authority of a province to deal with it, or the situation seriously threatens the ability of the Government of Canada to preserve the sovereignty, security, and territorial integrity of Canada. The government can make the case that either or both of these elements have been satisfied. It's clear the blockades endangered the lives, health, and safety of Canadians in downtown Ottawa. The diesel fumes, the constant and ear-shattering noise, the fireworks, and so many other things hurt the 12,000 Canadians living around the Ottawa blockade. The province of Ontario supported the invocation of the Emergencies Act, implying that the blockade exceeded the province's capacity to deal with the situation. The government can also argue that the situation seriously threatened its ability to preserve the sovereignty, security, and territorial integrity of Canada. The control of an international border is the hallmark of a sovereign state. At one point, 4 Canadian border crossings were blockaded: Windsor, Emerson, Coutts, and Surrey. The blockade of downtown Ottawa, the seat of our government and our national legislature, was also arguably a threat to the sovereignty and security of Canada, as was the call by some convoy organizers for the overthrow of government. The third criterion that must be satisfied is the situation, quote, cannot be effectively dealt with under any other law of Canada, end quote. It's important to note that the Act uses the word effectively rather than ideally. The government made an announcement about the public order emergency on the afternoon of February 14th, but the promulgation of the 3 orders in Council affecting the powers took several days. The blockades ended at Windsor on February 13th, Surrey February 14th, Coutts February 15th, and Emerson February 16th. It's clear that the border blockades were effectively dealt with under the existing laws of Canada and not under the Emergency Powers Act. Under the Emergencies Act powers, I should say. Here in Ottawa, while Emergency Act powers were used, they were not needed. Chris Lewis said exactly that yesterday. He said there was a lack of law enforcement and a lack of police officers, not a lack of laws to enforce. He said making arrests, seizing trucks, towing, cordoning off the city, putting up checkpoints, and getting thousands of additional officers to assist the Ottawa Police could all have been done under the existing laws of Canada. He's a former commissioner of the Ontario Provincial Police, the largest police force in the province of Ontario. Furthermore, it's clear that the Emergencies Act powers, allowing the government to seize financial accounts, could have been done under existing law. Ontario Attorney General Doug Downey did exactly that on February 10th when he obtained an order under Section 490.8 of the Criminal Code to freeze access to millions of dollars donated through the platform Give, Send, Go. Lawyer Paul Champ also did exactly that on February 17th when he obtained a Mareva injunction under existing common law that froze millions of dollars, including cryptocurrency, raised for the convoy protests. These actions by the Attorney General and by Paul Champ were done under the existing laws of Canada and also were done with court approval, unlike the Emergencies Act powers to freeze accounts without court approval that this government has now claimed for itself. These emergency powers may not, in fact, pass the Oakes test with respect to the proportionality or the requirement that they minimally impair rights and freedoms. The government has not met the requirement of the Act that the situation cannot be effectively dealt with under any other law of Canada. And therefore, Madam Speaker, I cannot support the motion. And I would add, if the House supports the motion, it might be giving government powers it likely does not lawfully have under the Act. And while I cannot support the motion, it's clear that the blockades in Ottawa and at the border were unlawful, illegal, and in many aspects criminal. It's also clear that the existing laws of Canada did and could have effectively dealt with the situation. A lack of timeliness in law enforcement and a lack of federal-provincial cooperation and other operational deficiencies cannot be dealt with under the Emergencies Act, nor under the emergency doctrine of peace, order, and good government. The failure to uphold the rule of law is the issue here, not a lack of law to effectively deal with the situation. In a free and democratic society, the rule of law is essential. Without the rule of law, there can be no freedom, because liberty without lawful limits, taken to its logical conclusion, is anarchy. Without the rule of law, there can be no democracy, because democracy without our most basic law, our Constitution, is nothing less than majoritarian mob rule. It's clear we as a country have not been serious about the rule of law. And because we've not been serious about the rule of law, thousands of Canadians thought it appropriate to unlawfully and illegally blockade 4 international border crossings and our national capital for more than 3 weeks. We've not been serious about the rule of law when a person's race, religion, creed determines whether or how the law is enforced. When the CN mainline in Ontario and pipelines in Western Canada were blockaded for weeks on end 2 years ago, and when the lawlessness continued last week. When the mob violently tears down statues in the public square with no consequence. When dozens of Canadian churches are vandalized or torched in the past year. When, in this place, the Prime Minister violates the Shawcross Doctrine of the Constitution by pressuring the Attorney General to drop the criminal prosecution of SNC-Lavalin, something for which he was never censored or held in contempt. And last year, when the government defied 4 orders of this House and its committee for the production of the Winnipeg lab documents. If flagrant disregard for the rule of law is tolerated, things will fall apart, the centre cannot hold, and anarchy is loosed. Madam Speaker, what is needed now is not the use of the Emergencies Act, but rather ensuring the rule of law in this country is upheld. Thank you.
Questions and comments.